Okay, welcome everyone. I'm going to be trying to control the slides. If I keep looking left, it's apologies. I've got multiple screens. So I've got faces to my left, slides, what you can see to my right, and I've got the mover slides in front of me. So if I keep moving my head, that'll be why. So thank you for coming. Hopefully we can make employment law as interesting as we can for you. And we are going to start off with a little bit from Zoe. Zoe, did you want to do a little bit more of an introduction on yourself?
No, that was me. All done. I've done what I had to do. Thank you.
Brilliant. Okay, in that case, we're going to move on to Kat and let Kat tell you all about herself. Over to you, Kat.
Thanks, Nikki. Hi, so I'm Kat Moody. I'm a dispute resolution and employment lawyer at Richard Reed Solicitors based in Sunderland. I've been studying and working in law for the past 24 years, qualified in 2013, and since then have predominantly spent my time dealing with, excuse me, contentious litigation. For the last 6 years, I've had a keen interest in employment law, and that's where I spend a majority of my time dealing with employment law and disputes at the moment. Thank you.
Thank you, Kat. Okay, so a little bit about myself. So for those who haven't already met me, my name is Nikki Masterman and I'm the founder and managing director of Inspired HR. I've done HR for over 30 years and there's very little that surprises me these days. I'm probably safe to say there's not much I haven't come across. For anyone that has met me, I absolutely love what I do, and I'm passionate about having a fantastic business that supports our clients, and we're quite pragmatic and very simple in our approach. So when we do talk about today, I will try to keep the employment law as simple as I can for you, but full of energy, love what I do, and I'm very, very passionate about doing it right for our clients. So we are a fantastic business and I have a fantastic team. I am a mum, a wife, I also have a grandson, and you'll see him in the next slide. My grandson Grayson was a baby born with Down syndrome. He's quickly approaching 3 years old. So if you follow me on LinkedIn, you will see that my family is all about the way I run my business as well as my life. It's all about my life as well. So that's a little bit about me, guys. So we're going to take you through some of the upcoming law for April. And me and Kat are going to be playing tag team. So we're going to take turns at talking about slides and different things. And I am going to hand you over to Kat first for the next slide, which is all about, when it thinks about it, whoops, there we go, carers leave. Over to you, Kat.
Thank you, Nikki. So yeah, as Nikki said, it's just really a brief update in respect of some of the new laws that are coming into place this year, predominantly in April, which is what we're focusing on today. So I wanted to firstly talk about the new law that's been introduced on the 6th of April. So this is a brand new law in respect of carers leave. So currently there's no specific rules or rights concerning carers leave. And it's reported that the failure to provide carers leave to employees has resulted in a lot of employees either reducing their employment hours or leaving employment altogether so that they can care for their dependents. So the government has introduced a new law in order to make that a little bit easier for people who have care and responsibilities. So as I said, from the 6th of April, a new law, the Carers Leave Act, will come into force. And the regulations that cover the regime are intended to come in place alongside that. The law provides that it will be a day one right, so employers now have to provide employees who meet the criteria with carers leave if requested. So an employee who meets the criteria can take up to 1 week unpaid leave in any 12-month period. And the criteria is that the employee is somebody who needs to provide or arrange care for a dependent with long-term care needs. So I suppose the question is, what does that actually mean when you break it down? So first of all, what is a dependent? Well, a dependent in the legislation is anybody who is a spouse, a child, an elderly parent, or somebody who someone who lives in the household who that person has a responsibility for. And also long-term care need, that has a wide-reaching definition, and it includes disabilities under the Equality Act. It also includes people of old age, although the Act doesn't go on to define what old age means. And it also includes caring for somebody who has an illness or an injury which is expected to require care for at least 3 months. So it is quite a wide-reaching definition. And what the law says is that an employee who effectively self-certifies that they're a carer can request carers leave by giving their employer notice twice as long as the leave they intend to take. So for instance, they're allowed to take a maximum of 1 week. It does not have to be in a block. They could take it in chunks if they like, as long as it's more than half a day at a time. They do not have to provide evidence that they are a carer, and their employer cannot ask for evidence. So you simply have to take your employee's word that they say they meet the criteria. Once an employee has made a request, you cannot reject their request, but if needed, you can postpone it for business needs. So I suppose because this is a new piece of legislation, you need to consider what you now need to do as an employer. And it will be things like, which I know Nikki's going to touch upon later in general, but in specifically for this, you need now to look at, do you have a policy at all? You might already provide carers leave, which is not currently a statutory requirement. But if you don't, you need to make a policy to ensure that you're covering all of the rules that are now being introduced. You need to train staff, and you also need to make sure that your employees know what their rights are and that they now do have this carers leave right if they do have somebody that is dependent upon them. And I'm going to pass you now over to Nikki, and she's going to talk to you about part-time worker in a regular holiday entitlement.
Thanks, Kat. Just to add on the back of the Carers Leave Act, guys, I just want to make sure that everyone understands that the Carers Leave Act and the Carers Leave is completely different legislation to the emergency dependent leave. This new legislation is where you're required to put in writing the request to take up to a week off in that 12-month period with notice to be given. However, emergency dependent leave, when they phone you on the day, which is where they are allowed a reasonable amount of time off, is a completely different piece of legislation. So they are two different things. So just making sure people understand the difference between the two. This is the one that you have to give notice on. The other one is emergency dependent leave, where they may phone up on the morning because their child is ill and they can't come in. They're two different things. So just making sure people understand that one, because I know that's going to arise. Now, here's me ready to talk about one of my favourite subjects, holidays. So you will all remember we did quite a big piece in July 2022 in relation to, there was a court case called the Harper Trust versus Brazil in July 22 that went to the Supreme Court and had a massive implication in relation to 0-hour contracts. Now, on the back of this, we obviously updated our clients. We updated our 0-hour contracts and our casual contracts from the 12.07%, which became unlawful, to the 5.6 weeks. Now, there was a lot of lobbying to the government in relation to this, because it really put a lot of pressure on the SME market in relation to the cost of holidays and trying to manage that now with 0-hour employees. So the government listened, and they've now done a bit of a turnaround on that. So they're actually now reintroducing the 12.07% for 0 hours. Now they call it part-year workers and irregular hour workers, but basically it is your 0 hours and your casual. Now, please don't confuse this with term time working or annualized working, where they might have certain points off in the year. They are not affected. This is purely affecting 0 hour, as I refer to it and simplify it as, and your casual contracts. So these are people that do take at least 7 days off in the 12-month period as unpaid time because they're not required to work or they're not available to work. Now, just a few reminders in relation to a few things on this. It is called under the legislation part-year work and irregular. I refer to it as zero and casual. You can take the people back to 12.07%. Now, the date of the introduction on this is the 1st of April, but don't confuse this with you can make the change from the 1st of April. So the legislation comes into force from the 1st of April, but whether it's relevant to your business will actually depend on your holiday year. So for example, if your holiday year is April to March, then yes, you can start using the 12.07% again. From the 1st of April. However, if your holiday year is January to December, you won't be able to take this calculation and use this calculation and change to law until January 2025, because you can only start using it from the beginning of your holiday year. Now, the other thing that's coming back into this is not only is it the 12.07% of hours worked, which makes it much more affordable for businesses, and bear in mind, this is great, but only when they are a genuine 0-hour contract. The other thing that's coming into force that you can also now use in this, which we didn't have before because it was taken away many years ago, is rolled up holidays will now also be allowed. Now, for those that don't know what rolled up holidays are whereby if someone works 100 hours in that given month, and at the end of that month, you calculate that 12.07% of those hours, and what that value is, rolled up means you can actually just pay it in that pay slip. So you'll be paying them for the 100 hours, and the rolled up means you are now paying them the 12.07% in that pay slip, but it must be separated on the pay slip. Don't add it into the normal hours. It needs to show as holiday underneath for that period. Now, there is always the danger with rolled up holidays that if you have someone who's working a lot of regular hours and they are working many weeks, there was a couple of arguments on this. One, are they a genuine 0-hour contract if they are working so many hours and so regularly, or can you justify that they do actually have a break in service throughout that year? But the other thing to remember about rolled up holidays is that person genuinely getting a rest period if they're working a lot of hours and you're paying the holidays in a rolled up fashion. So bear in mind exhaustion, burnout, and whether people are genuinely getting the rest period that they need. Now, a couple of other things to be aware of in relation to this change is you will remember during the pandemic, you were allowed to carry over holidays that employees weren't able to take during the pandemic. If you have carried over any holidays in relation to the pandemic, please ensure they take it by the 31st of March. They cannot be carried over further. So that is the deadline for any holidays carried over from the pandemic. Another change which has happened recently is there used to be what we called a 3-month time limit. If someone had been underpaid on holidays, it had to be within the last 3 months for them to request to be paid any underpaid holidays for the prior 2 years. That 3-month has been diminished. So now if you have an employee that has been underpaid in the last 2 years, please be aware they retain the right to ask to have those holidays corrected and be paid for that time. So that 3-month time limit has also been diminished. So be aware that doesn't exist and make sure you're paying correctly. We are updating our contracts for our clients and reintroducing these, and we will be in contact with you in relation on how to roll this out and how to move your people from 5.6 to 12.07%. And that's the holidays, guys. A little bit more complicated, but it is making your life easier again with your 0-hour and casual workers. Back to Kat.
Thank you, Nikki. I don't know if anybody else agrees, but I find holidays are very difficult to get your head around sometimes. So it's always worth. I think you've got a little bit more kind of. Well, I think you were talking about another webinar potentially in the future about a bit more about holiday entitlement, and there's a lot of literature out there if anybody needs more information.
There is. So just going back to what Kat says there, just be aware with holiday calculations, there is 2 different calculations with holidays. There is the holidays of what they're entitled to, which is the 5.6, but what you actually pay them is a completely different calculation. So please be aware with holidays, they're two different calculations, and I am planning to do another webinar with more detail on holidays and how to calculate holiday and pay. And we also do have a holiday calculator template we have created, which we will be sending to all attendees once I've updated it with both different types of calculations. Back to you,
Great,
Kat.
thanks, Nikki. Thank you. So now I'm going to go on to something that's a little bit more easier to understand than holidays, and that's the flexible working reforms. So I'm sure everybody's aware or have heard the term flexible working request, especially post-pandemic. A lot of people needed flexible work and much more than they had previously. But for those that don't understand what flexible working is, I just wanted to give a little reminder to let you know that it's covered by Section 80F of the Employment Rights Act. And in that legislation, it provides that an employee has a statutory right to request a variation to their employment contract in respect of the hours they work, in respect of the times they work, and in respect of the places that they work from. And that is what's referred to as a flexible working request. So currently, the law provides that you have to have 26 weeks continuous service in order to make a flexible working request. And once you've put that request in writing, your employer has 3 months to consider that request before they notify you of the outcome. The outcome can only, if the employer, is going to reject the request, it has to be one or more of 8 permitted grounds, such as there would be a burden of additional cost on the employer, it would be a detrimental effect to meeting customer needs, or they have an inability, for instance, to recruit additional staff to cover the flexible working variation. So an employee can only currently make one request in every 12-month period. And so there's not really a lot of flexibility. If that's denied, an employee has to wait until that period expires before applying again. So the new changes come into effect on the 6th of April, and what they provide is that now, from the 6th of April, all employees will have a day one right to file a flexible working request with their with their employers. So it no longer matters how long an employee has been employed, they have that right from day one. And so the thing that got me thinking there was that it's perfect time for employers to start thinking about how will that impact on their recruitment process, because now, perhaps previously, in adverts and during the recruitment process, the flexible working patterns suitable for particular roles might have not been advertised as such, because everybody assumes that everyone will work to the same pattern, which of course is no longer the case. So it is possible now, when you're making adverts, putting adverts out there for jobs, to include the type of pattern you would expect to see a person working to for that particular role. And also during an interview, for instance, with an applicant, you can ask open questions of the applicant as to what pattern they would think suitable for them if they were to take the job. But you must make sure that you don't ask anything discriminatory. And you must never assume that a particular person will want to work a particular work pattern simply because they have a particular characteristic. So it is a little bit of a complex area. You must never do anything which may be seen as discriminatory. There's also going to be some regulations coming into effect, hopefully by July, and ideally in line with the April change. And this is to set out the procedure which will now apply for flexible working. So the procedure is changing slightly. An employee now gets 2 opportunities to make a flexible working request in any 12-month period, rather than just one per 12-month period. And an employer must now deal with your request within 2 months rather than within 3 months. The request, if denied, must be consulted with the employee before they are notified that it has been denied. And both employers and employees are now encouraged to review the ACAS code, which will also be published hopefully in April, setting out hints and tips for dealing with the new regime. So there are slight changes to the regime. in terms of time periods applicable, and also, most importantly for employees, that it is now day one right. So things again to think about from an employer's point of view, making sure your policies are updated, making sure staff who will be dealing with the requests are suitably trained, and also making sure your employees know what their rights are, that they do have this day one right, and making sure everybody's fully aware of the changes ahead of April. And I'm now going to pass you over to Nikki, and on my notes it says here that Nikki is going to be dealing with protection from redundancy.
Yes. Just to let you know, on the back of this flexible working, guys, we will be designing and delivering some training on this, because it is going to become a bit of a risk for businesses, especially where you recruit someone and on day one slap in a request to work from home or hybrid working, which was never part of the original job offered and accepted. So I've already spotted a lot of risks on this. We are still waiting, like Kat said, for the process to come forward and let us know what does that consultation look like if you're going to be in a position to deny that request in relation to the 8 reasons of refusal. So I know we'll be working with clients on this, and we can help our clients handle these, but I will also be designing some training on it, because it is a risk if it goes wrong. So the next one for me is the protection from redundancy for Pregnancy and Family Leave Act. So from the 6th of April, many of you will be aware that anybody who has been on maternity or is on maternity has specific rights when it comes to redundancy process anyway. There has always been a preferential that there is a need to offer alternative suitable employment to individuals, and there's always been a level of protection there. However, it's been heavily enhanced. So this is going to affect anybody that has been on maternity, adoption leave, shared parental leave. It's not just affecting individuals that have been off on maternity. It is affecting individuals that have been on adoption and shared parental leave. So what does this protection look like? Well, basically, from the moment an individual makes you aware they are pregnant, they are automatically protected under this Act. They are also protected for up to 18 months after they have given birth. So what does that look like in reality? Because I'm always that person that looks at what reality looks like for you. And I will always look to some of the challenges that an employer may have in relation to this. I think it's a great piece of legislation in the view that it gives protection to individuals that have been off due to adoption, maternity or shared parental leave. However, it could also cause some challenges within businesses where a redundancy situation may arise. And I'll give you an example of what that could be. So imagine you've got 2 individuals that both do the same role, and one of those individuals is still within the 18 months of protection. They actually, if you need to reduce those 2 jobs to 1, even if the person that has not been off and had that baby on maternity leave is the better skilled person, and if you did a matrix and scoring matrix and they were higher and the higher skilled person, you're actually still obliged to offer that job to the person that is protected. So it is going to bring some challenges when a redundancy situation arises, that there is a much longer time frame of protection now for that individual that has had that leave and will automatically have the right to be offered a suitable alternative ahead of other employees. So it is going to bring some longer period of challenges for businesses to consider. So the protection comes from the point that they inform you, and it is now extended to 18 months after birth or placement. So it's just an enhancement of the current legislation rather than a whole piece of new legislation. And it will have its challenges. So we do always recommend that if you think you're in this situation, then do give us a ring so we can spot any potential risks for businesses. And that's protection from redundancy, guys. Next, we have paternity leave.
Great, thanks, Nikki. So another change concerns the reforms of paternity leave regime for fathers and partners who want to take paternity leave. So the current law provides that paid paternity leave can be taken in a single block of 1 week or 2 consecutive full blocks within 56 days of the child's birth or the adoption date. An employee must have had 26 weeks continuous service at date 14 weeks of the child's expectant birth date. And also the employee must give everything to the employer at the outset. So 15 weeks before the expected date of birth, the employee needs to tell the employer that they're entitled to paternity leave, and also needs to tell them the dates that they intend to take off as leave. So it's quite front-loaded from the employee's point of view, and also it's not always possible to know exactly when you want to be off. And also it's quite a short window of opportunity. 56 days from the date of birth isn't a particularly long period of time to take that leave. So the changes that come into effect on the 6th of April, albeit they are relatively minor, do still need to be brought to your attention, because of course policies and procedures will need to be updated, and staff will still need to be trained so they know what the new changes are, so they can deal with them correctly. So the new changes provide that paternity leave for children born or adopted on or after the 6th of April can now be split within two separate blocks of leave. So you no longer need to have to take it all together. You can take 1 week and then you can take another week later if you want to. And also you can do that within 52 weeks of the child's birth or the adoption date. So that gives a far longer period of time to take that paternity leave than currently is available for those that need to take that leave. The big change from kind of a HR point of view, really, in processing the leave is in respect of how the employee now notifies the employer. So previously, everything, as I said, had to have been done on or before 15 weeks ahead of the expected birth date, and now that changes. So the entitlement still needs to be brought to the employer's attention 15 weeks ahead of childbirth, but the notice for when you actually want to take time off only now needs to be 4 weeks rather than 15 weeks ahead of childbirth. So it does give employees that bit more flexibility to take some time and think really when it is that they would be most when they want to take the leave and when it would be most beneficial to them and their family. So as I say, it's only a relatively minor change, but your policies and procedures will still need to be updated to make sure that everybody is fully aware as to what they can do. And also if you use a prescribed form for employees to give you that notice of entitlement and request as dates, you might want to split that form up. So there's a form for there's a form for paternity leave entitlement, and then a separate form for putting in their leave request 4 weeks in advance. And that's everything from a paternity leave point of view. So relatively straightforward, but still worth knowing. And as I say, that comes in on the 6th of April. And so now I'll pass back to Nikki, and I think you're going to talk to us about pay rates.
I am. So, bear with me, there we go. So all the pay rates are due to go up from April. So there was a big change in the pay rates this year. As you all be aware, that the higher level of pay rate used to be 23 plus. It's now from April this year being dropped to 21 plus. So from a pay rate point of view, here's all of the pay rates. So apprentices are going from £5.28 to £6.40. 16 to 17-year-olds is moving from £5.28 to £6.40. 18 to 20-year-olds is going from £7.49 to £8.60. And then your 21 and 22-year-olds are going from £10.18 to £11.44, and your 23 plus. So it's basically 21 plus now, where they will all be moving to £11.44. Now, just something to consider when it comes to recruitment. I still see these new rates not being considered when I'm seeing jobs being advertised. So I just wanted to give you an idea of what the full-time equivalent of a 37.5-hour full-time worker is going to be in relation to a full-time salary. So a full-time salary now for someone working 37.5 hours, full-time equivalent is 22,307. So that is the minimum for 21 and over on what they are going to be paid. So bear this in mind when you start doing any advertisements for roles, because even now I'm seeing what should be deemed as skilled roles when I'm looking at some of the job sites. being advertised for £22,500. But if you see that these pay rates are going up, that's going to have a big impact on benchmarking for salaries and roles. So please do bear that in mind when you are recruiting. SSP rates are going from £109.40 to £116.75. And the statutory maternity pay is going from £172.48 to £184.75. The redundancy cap is also going to 643. So bear these in mind. Now, something to bear in mind with this, and I guess that's because I always look from a HR point of view of some things that might arise in the business. You may have a 20-year-old that is suddenly going to go from £7.49 to £8.60. But if they suddenly then turn 21 shortly after that pay rise in April, then they're going to quickly jump to £11.44. So be very aware, have a look at your budgets, have a look at your wages. That could cause some unrest and sarky comments between employees, where you've got a 20-year-old suddenly within, it could even be a week or even a day, going from £7.49 to £11.44. That is a big jump in their pay rate and could have a big impact on your bottom line and your wage budgets. So please do start thinking ahead of this. Have a look at your age groups within your business. How is this going to affect you in your budgets? And be aware to manage any comments within your business of what could be deemed as a bit of office banter between staff, and just manage that, because I have no doubt that someone will comment, these individuals have had a big pay rise, but obviously it's not something you've chosen to do, it is legislation, and obviously we deal with some of these things sometimes. So just something to bear in mind. Plan ahead, guys, and manage any office banter where people might be commenting on pay rises for those 21 and over. And I'm now going to hand you over to Kat, who is going to talk about the expected and upcoming changes, as there is a lot on the horizon.
Thank you, Nikki. Yeah, so 2024 does see a lot of changes to employment law and practice. And I don't for 1 minute intend to go through the long list that Nikki compiled earlier and nearly give me a heart attack when I saw how long it was, of all of the changes to policy and procedure that's coming in. But it was really just to give you kind of a snapshot of the types of things that you might want to start looking ahead at. And hopefully later in this year, myself and Nikki are going to do a further webinar to talk about those changes. But things on the horizon that you should keep an eye on are things such as allocation for tips. There's going to be new regulations in respect of what you do with tips that staff receive and what you can't do, most importantly, with them. Those changes are likely to come into effect in July this year. There's also going to be new regulations, which have been kind of a hot topic in the press recently in respect of fire and rehire. And that's where employers effectively dismiss staff and then rehire them on less favourable terms. That's been big business recently, and as such, regulations are now coming in to make sure that staff are protected. So those are expected to come in sometime in the summer. There's also changes to the right to request predictable working patterns. Again, that's anticipated to come in September. And then the big one that's especially I've been quite interested in looking at is the sexual harassment in the workplace. There's big changes afoot for that legislation, particularly putting extra duties or a new duty, I should say, on employers to prevent sexual harassment in the workplace. And that's likely to come into effect in October. So for the rest of the year, there are quite a lot of changes. And as I say, that's just a very small snapshot of the types of changes. The list is far longer, but it's just to make you aware that 2024 is really the year of change in respect of employment and HR practices. So if you're not up to date with them, then of course, feel free to follow myself and Nikki on social media, LinkedIn in particular. We do put a lot of things on there to bring matters to your attention as they arise. And we do hope to do another webinar later in the year to give you a little bit more information as and when it becomes necessary to do so. So I'll pass you back over to Nikki now, and she's going to give you a little hints and tips of next steps as to how to prepare for all of these changes.
Yeah, so there's actually 18, I've just counted on my list, 18 new legislations and changes coming. So quite a big list. Again, if you're not on our mailing list, please do get on our mailing list, because everything we've talked about today, we'll be sending updates out on, and we'll also be giving people a heads up on also what's coming, as there is a lot of big changes coming as well. It's a bit like buses, either none come or they all come at once, and we've certainly got quite a few this year. So some of the next steps I wanted to talk you through to start thinking about is start reviewing and looking at your current contracts, policies, handbooks, start getting them updated, start thinking about the changes. Be very mindful of your contracts and your handbooks as to whether they're contractual or not contractual. So what that basically means is some changes you might need to have to consult and give employees notice, others will just be non-contractual legislation changes. So please do start looking at those things for your business, because we are literally a month away. For any of our retained clients, you will already be aware, I've sent you an email, we are actually doing that for you. We're already updating your contracts, policies, creating your new ones as part of your package and sending them out. Any further ones this year that come into play will also be the same. We will update and send them out to you. Start planning for your pay rate changes, as some of these will be a real high impact on your wage budget and your business bottom line. Start making sure that your employees that have carried over holiday from the pandemic are aware that they need to be taken by the 31st of March, as you cannot carry them over further. Ensure you are working to the correct holiday calculations. We will be sending out the holiday calculator that we have created that enables you to track your weekly working hours, bonuses, overtime, commissions, and then you have two different calculator within the spreadsheet that is based on either whether they get paid on 5.6 or 12.07%. That calculator will be coming out once I've updated it with the 12.07%. Flexible working, I absolutely manage. There's going to be a lot of pitfalls with this if recruitment is not done right. Some of the things to be very conscious of when you recruit is please make sure that the hours and the location, you have a business case for when you advertise, and that's what the role sits at. So you can try and stop any day one requests coming in, so you kind of stop that. So during the recruitment, you're making it very clear why the hours are in that way, why the location or working from the office is where it is, depending on where it is. So that trying to stop some of that straight away. If that's not clear, there will be individuals starting to request hybrid or working from home on day one. So be really clear that why that role needs those hours and that location, so that you're all prepared for what may come. Start considering some of the upcoming changes as well, and we will be communicating that. Now, for those individuals that are on this meeting, we do, if you are not a retained client and you are a pay-as-you-go client or not a client at all with us, we do offer multiple services, including template documents, getting your handbooks and contracts updated or re-implemented, and we do holiday calculations and various services. So if you would like our information on our different services, then please do let us know, as we are offering 10% off some of the changes, but I'm not going to go into big sales or I'll get told off by Zoe. And now I'm going to hand over to Zoe, and if you have any questions, please put them in the chat, and myself and Kat will do our best to answer them for you.
That was amazing. Thanks, Nikki. Thanks, Kat. Well, I say amazing quite loosely. You know, it's quite, you've got a tough gig, haven't you, trying to make this stuff interesting. Is it always like this? So a question from me, first of all, like every time that these employment law things, like does that many things change? Because 18 seems like, how are small businesses supposed to keep up with that unless you know, is that unheard of? Is that a lot?
So from my point of view, I've done this for over 30 years and I've never seen this many changes in one hit. I mean, we've got all of the changes that me and Kat have talked about today, but the 18 is what's upcoming. That's without already what's happening in April. So we've got all these changes in April, plus all of the upcoming, which is 18, which is still in talks and going through and everything at the moment. I've never seen it. I do think Brexit has had a big impact on it. I also, because I'm seeing changes in relation to GDPR and other things as well. And I do also think the pandemic has had an impact on that. So I do think a lot of this is where things have been held off or things have been considered due to the pandemic and Brexit. But I've certainly never experienced this many in one hit.
Mm-hmm. Yeah, I would agree with that, Nikki, that it seems that there's a lot more changes afoot this year and for the rest of the year than I've seen in my time dealing with employment law. And also we're talking about the changes that are taking place in April and beyond, but there were changes earlier in the year from January in respect of discrimination and other legislation. So actually throughout the year, there's quite a lot. There's quite a lot of changes, but no, Zoe, there's not really, it seems quite extraordinary really to have so many changes in a relatively short period of time. That's, you know, if you break that down over the months, that's pretty much every month you've got something to contend with, something to put into place, changes to be made. And I think the only really way that employers can deal with it is by trying to stay ahead of the curve, attending things like webinars, researching, signing up to kind of newsletters and things like that, just to keep abreast of what's actually going on, because it is impossible task to do it yourself and run a business.
Mm-hmm.
Yeah, definitely.